My children took me to court to take my home and put me in a nursing home. My son's lawyer smirked. She has no chance. But I said 3 words. The judge dropped his papers and, "Good day, dear listeners. It's Clara again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. I have lived in the same house on Elm Creek Road for 51 years. I want you to understand that before I tell you anything else, because the house is not just a house. Harold and I built it, not with a contractor, not with hired hands, but with our own savings, our own weekends, our own blistered palms. We planted the oak tree in the backyard the summer Daniel was born. We painted the kitchen yellow the year Linda came home from the hospital. Every scratch on the doorframe was a child's height recorded in pencil. Every creak in the 3rd stair was the sound of a family growing up. Harold passed in 2019. Prostate cancer. He went quietly in the bedroom we shared for 43 years, with my hand in his and the ceiling fan turning slowly overhead. I grieved. I grieved deeply, the way you grieve when someone has been the other half of your breathing for so long that you aren't sure which thoughts were yours to begin with. But I did not fall apart. I am 74 years old. I have buried a husband, a mother, a best friend, and a dog I loved more than some people I've met. I know how to carry weight. After Harold died, I settled into a quieter life. I tended the garden. I had my book club on Thursdays. Ruth, Connie, Beverly, and I had been meeting since 1998. I drove myself to the grocery store. I cooked proper meals. I was not frail. I was not confused. I was a woman living alone in her own home, which is a perfectly ordinary thing to be at 74. Daniel called more often after the funeral. That should have been my first sign. My son is 51 years old. He works in commercial real estate in Phoenix, which is a 4-hour drive from my house in Tucson. He has a wife named Cheryl, who has always looked at my furniture like she's pricing it, and 2 teenage sons who I love, despite the fact that they cannot hold a conversation longer than 30 seconds without checking their phones. Daniel was always the practical one. Harold's word for it was practical, though I sometimes thought calculating was closer to the truth. He could look at any situation and find the angle that served him best. I used to admire that. I used to think it was intelligence. Linda is 47. She lives 20 minutes from me, which means I saw her far more than I saw Daniel, though I'm not sure that translated into closeness. Linda is soft-spoken in public and sharp-tongued at home. I'd watched that pattern her whole life. She married a man named Greg, who lost his accounting job in 2021 and had not, as far as I could tell, replaced it. They had 3 kids and a mortgage, and a lifestyle that I suspected cost more than it should. The calls from Daniel started in late 2022. Friendly at first, checking in, asking how I was feeling, whether I'd been to the doctor, whether I'd had any trouble with the stairs. I answered honestly. I was fine. Yes, I'd had my checkup. No, the stairs were not a problem. Then he started visiting. 3 weekends in 6 months, which was more than he'd visited in the previous 2 years combined. He brought Cheryl. They walked through the house with their eyes moving in ways that made me feel like I was already gone. Linda, meanwhile, began stopping by unannounced. She'd find small things to worry about. A dish left in the sink, a bill on the counter she deemed unpaid. It was paid, I'd simply not filed it yet. Once a single burned-out light bulb in the hallway, that she photographed with her phone before I could change it. I noticed the photographs. I didn't say anything. I filed the observation away in the back of my mind the way you file things you hope you'll never need. The first real moment, the one I kept returning to later, the one that should have made me act sooner, happened on a Sunday afternoon in March of 2023. Daniel and Linda were both at the house, which was unusual. They said they'd coordinated the visit to surprise me. We had lunch. We talked about the grandchildren. And then, over coffee, Daniel set a manila folder on the kitchen table. "Mom," he said, "we've been talking, and we think it might be time to consider some options." Inside the folder was a brochure for a senior living facility called Sunrise Pines. Private rooms, organized activities, memory support services, which is a phrase designed to make you feel that needing it is inevitable rather than exceptional. I looked at the brochure. I looked at my son. I looked at my daughter, who was examining her coffee cup. "I'm not moving," I said. Daniel smiled. The patient, measured smile of someone who believes the conversation is already decided. "Nobody's saying you have to do anything right now. We're just starting a conversation." But I knew, sitting in my own kitchen, at my own table, in the house Harold and I had built with our own hands, that this was not the beginning of a conversation. It was the beginning of a plan. And I had not yet begun to make mine. I didn't sleep that night. I lay in the bedroom Harold and I had shared, and I stared at the ceiling, and I let myself feel the full weight of what had happened at that kitchen table. Not the shock of it. I am too old for shock. But the grief of it. The particular grief that comes when you realize that people you loved, people you raised, have been calculating behind your back. I thought about the brochure. Sunrise Pines. I had looked it up before bed. It was 45 minutes away in a suburb I'd never had reason to visit. The rooms were small. The reviews were middling. The monthly cost was $4,200, which, if you were a person who had just looked up how much a house on Elm Creek Road was worth in the current Tucson market, and I had, also before bed, told a very clear story about who would benefit from the arithmetic. My house had been appraised the previous year for $410,000. Harold and I had paid it off in 2001. There was no mortgage. There was no lien. The house was mine, free and clear, and had been for 22 years, $410,000. Divided by 2. I lay there in the dark, and I did the math my children had already done, and I felt something shift inside me. Not collapse, not despair. Something harder than that, and colder, and more useful. Fear came first, though. I won't pretend otherwise. I was a 74-year-old widow living alone, and my children had lawyers. I was certain of that because Daniel does not make moves without lawyers. And I had spent 51 years being a mother and a wife and a gardener and a reader of books, not a litigant. The legal system was not my native country. But then I thought about Harold. Harold was a quiet man, but he was not a passive one. He used to say, "The person who prepares wins more arguments than the person who is right." He'd said it about business negotiations, about difficult neighbors, about the time our insurance company tried to underpay a roof claim, and he'd spent 6 weeks documenting every conversation until they capitulated. Preparation. Documentation. That was Harold's language. I got up at 5:30 in the morning and made coffee and sat at the kitchen table, the same table where Daniel had laid down that folder, and I opened a notebook. I wrote down everything I could remember from the previous 6 months. Every visit. Every question about my health. Every photograph Linda had taken. The dates, as precisely as I could recall them. The exact words Daniel had used. "We've been talking." We think it might be time. Starting a conversation. The way Cheryl had walked through the living room with her eyes moving over the furniture. Then I wrote down what I knew about myself. I was in good health. My doctor, Patricia Huang, at the Rincon Medical Group, had cleared me at my annual physical 8 months ago. Blood pressure normal, cognition sharp, no balance issues, no fall history. I drove, I cooked, I managed my own finances. I had not, in recent memory, left the stove on or missed a bill or gotten lost in a place I knew. I had a will, drawn up in 2020, which left the house to Daniel and Linda in equal shares upon my death. That was no longer a document I felt comfortable leaving unexamined. I called my book club friend Connie that morning. Connie Abernethy had been a paralegal for 30 years before she retired, and she had the kind of practical legal knowledge that is more useful than theory. I told her what had happened. There was a long pause on her end. "Margaret," she said, "you need a real estate attorney and an elder law attorney, and you need them before your kids make their next move." "I know," I said, "and you need to protect that deed." I didn't know exactly what she meant by that yet, but I wrote it down. That afternoon, I drove to the public library. I still preferred to research in quiet spaces, away from the house where I was increasingly aware that my children might have keys. And I spent 3 hours reading about guardianship proceedings, conservatorship, and what in the state of Arizona constituted grounds for challenging a senior's right to independent living. What I found was sobering and clarifying in equal measure. To remove a person's legal autonomy in Arizona, a petitioner must demonstrate that the person is incapacitated, unable to manage their own affairs due to a mental or physical condition. The standard requires medical evidence. It requires a court appointment. It is not, in theory, easy to obtain without genuine cause. In theory, but I also read the case studies. I read about families who had coached physicians, hired compliant evaluators, and presented selectively edited evidence to overworked probate judges. I read about elderly people who had walked into courtrooms independent and walked out legally stripped of their own decisions. I closed the laptop and sat for a moment in the library's quiet. Then I opened my notebook to a fresh page and I wrote at the top, my plan. It was going to take time. It was going to take money. It was going to require me to be patient and precise and absolutely, relentlessly prepared. I was 74 years old, and I had been underestimated my entire life. I was about to stop allowing it. The first call I made was to an attorney named Robert Castillo. Connie had given me his name. She'd worked with him years ago on an estate case and described him as thorough, unhurried, and not given to false reassurance, which was exactly what I needed. His office was on the east side of Tucson, in a low building surrounded by mesquite trees, the kind of place that didn't advertise on billboards. I liked that. I told him everything. The folder on the table, the unannounced visits, the photographs, the brochure, the conversations about my health that had never once asked how I felt, only whether I was capable. He listened without interrupting, which I appreciated, and then he asked me very specific questions. Did I have a copy of my current will? Was the deed to the property solely in my name? Had I signed any documents for my children, powers of attorney, healthcare proxies, anything at all, in the past 3 years? I had signed nothing. He nodded slowly. That's good. That's actually your first line of defense. They have no current legal authority over you or your affairs. Can they get it? They can try to petition the court for guardianship or conservatorship. That's what this is building toward, in my assessment. They'd need to demonstrate incapacity. He paused. Have you had a recent medical evaluation? I had. I told him about Dr. Huang. He asked me to request a copy of the records from that visit, specifically the cognitive screening results. He also recommended I schedule a new evaluation, comprehensive, including neuropsychological testing, with a specialist he trusted, so that I had an independent, current, and thorough document of my mental and physical capacity. Not because there was anything wrong with me, he said, but because in a courtroom, documentation beats testimony every time. I left his office with a list of 4 action items and a retainer agreement. I wrote a check without hesitation. This was not the time to weigh costs. The neuropsychological evaluation was scheduled for the following week at a clinic near the university. I drove myself there and spent 2.5 hours being tested on memory, attention, reasoning, processing speed, and executive function. The psychologist, a calm woman named Dr. Reyes, told me at the end of the session that my scores placed me in the above-average range for my age group across all domains. I thanked her. I asked for the report in writing as soon as possible. It was during this same week that I noticed the first sign that Daniel and Linda were paying attention. Linda called on a Tuesday evening. Nothing unusual in that. But the questions were different. She asked if I'd talked to anyone about the conversation we'd had at the house. She asked it casually, the way you ask something when you're hoping the answer is no. I told her I'd spoken with Connie, which was true, and mentioned nothing about Robert Castillo. There was a pause. Connie Abernethy? Why? She's my friend, I said. I talked to her. Another pause. Mom, we're just trying to help. We don't want this to become adversarial. The word adversarial told me everything. You don't use that word unless you've already been thinking in legal terms. The second sign came 3 days later, when I discovered that Linda had spoken to my neighbor, Patricia Walsh, asking whether she'd noticed anything concerning about my behavior recently. Patricia told me this herself, standing at my back fence with a look of uncomfortable apology on her face. She said Linda had implied she was asking on behalf of the family and had asked specifically about whether I'd left the garage door open overnight, whether I seemed forgetful, whether I'd had any visitors she didn't recognize. Patricia had told Linda she had no concerns. She told me she thought the whole thing was odd. I thanked her and went inside and sat down at my kitchen table and wrote it all in my notebook. Date, time, what was said, who witnessed it. The systematic questioning of my neighbors was not the behavior of people having a casual conversation. It was the behavior of people building a record. The third, and most important, sign came at the end of that week. I had requested a copy of the deed to the house from the Pima County Recorder's Office, simply to have it in hand and to verify its current status. The clerk's office sent me a printout showing the current title history. Everything was in order. The deed was in my name alone, as it had been since Harold's death, when it transferred to me under the right of survivorship we had established decades ago. But there was also a notation I did not recognize. A title search had been run on the property 6 weeks earlier. Not by me. Not by any bank or lender I recognized. By a law firm in Phoenix, Hartwell and Briggs, LLP. I sat very still for a long moment. Then I called Robert Castillo. That's Daniel's attorney, I said, reading him the firm name. Yes, he said. It is. A brief pause. Margaret, they've already started. I already knew that. But hearing it said plainly by a man whose job it was to know what things meant made it real in a different way. This was no longer a conversation about a brochure on a kitchen table. This was a lawsuit in the making, and I had just found the first piece of evidence that proved it. Robert Castillo moved quickly after the title search discovery. Within 10 days, he had filed a quiet title action on my behalf. A legal proceeding that formally established the property as solely mine and put any future claim to it on record with the court. He also drafted a formal cease and desist letter addressed to Hartwell and Briggs, informing them that I was legally represented, that any further attempts to investigate or encumber my property without my consent would be challenged, and that I was documenting all contact. He sent a copy to Daniel. I would like to tell you that I felt triumphant when he told me this. What I actually felt was tired and then resolved, and then something close to sad. The specific sadness of a person who hoped, even at this late stage, that she had misread the situation, that the title search had an innocent explanation, that her son would call and say there had been a misunderstanding. Daniel called on a Thursday evening. It was not the call I had hoped for. "You hired a lawyer." His voice was controlled. He was not shouting, which was more unnerving than if he had been. "Without telling us, without even giving us a chance to explain." "Explain what, Daniel?" "The title search was just research. We were looking into options for estate planning, for after—" He stopped. "For after I die? For after you're no longer able to manage things independently, which is going to happen, Mom. That's just reality." "It hasn't happened yet," I said. "And until it does, my house is my house." There was a silence that lasted long enough for me to hear him breathing. Then, "You're making this very difficult." I said nothing. "We're your family. We're trying to protect you." "From what?" I asked. "From living in my own home?" He hung up. Linda came to the house 2 days later. She did not knock. She had a key, which I had given her years ago for emergencies, and which I had not yet thought to change. And I heard the front door open while I was in the kitchen. She came in and sat down across from me, and for a moment she simply looked at me the way you look at a problem you're calculating. "Daniel is very upset," she said. "I imagine he is. Mom, do you understand what you're doing? You filed legal papers against your own family. Do you know how that looks?" "I know exactly how it looks," I said. "It looks like a woman protecting her home." Linda's composure cracked slightly. Not much, but enough. "We have documentation, you know. We've been keeping records. You left the stove on in February. You forgot Ruth's birthday. You told me the same story about your doctor's appointment 3 times in 1 week." I set down my coffee cup. "I left a burner on low while I went to the back garden for 10 minutes. Ruth's birthday is in March, and I sent her a card on the 5th. And yes, I told you about the appointment more than once because you seemed distracted, and I wasn't sure you'd heard me." She blinked. "I have been keeping records too," I said quietly, "since March of last year." The silence that followed was the kind that changes the temperature of a room. Linda stood up. "You're going to regret this. Daniel has resources. He has a very good attorney, and he knows how to—" She stopped herself. "How to what?" I asked. She left without answering. That night, Daniel called again, and this time his voice was different, tighter, and with an undertone of something I recognized from his adolescence, the particular register he used when he knew he was losing an argument, but hadn't accepted it yet. "We've consulted with our attorney," he said. "We're filing a petition for guardianship. Voluntary or not, this is happening. And if you fight it, it's going to be expensive and public, and you're going to end up looking unstable in front of a judge." I let him finish. "I have a neuropsychological evaluation completed last week, showing full cognitive capacity," I said. "I have a primary care physician who will testify to my physical health. I have documented every interaction we've had for the past year, including this phone call, which I should mention I began recording when you started speaking." Another silence. "Good night, Daniel," I said, and I hung up. I sat in the kitchen for a long time after that. The house was quiet. The oak tree in the backyard moved slowly in the evening wind. I thought about Harold, the way I often did when things were difficult. Not with longing, exactly, but with a kind of consultation, as if I could still ask him whether I was handling this right. I thought he'd say I was. I took 3 days after that. I put the notebook in the drawer. I went to book club. I had dinner with Connie and Ruth, and we did not discuss the case at all. I let myself sit in the garden in the late afternoon warmth and watch the birds at the feeder Harold had installed the year before he got sick. I was going to need my strength for what came next, and I intended to have it. The offer came on a Monday. Daniel called. Not in the evening this time, but mid-morning, which felt calculated, as if he expected me to be more receptive in daylight, less guarded. His tone had changed again. It was warmer now, conciliatory. The voice of a man who had decided, on advice of counsel or by his own instinct, that confrontation had not worked, and charm was the next instrument to try. "Mom," he said, "I owe you an apology." I waited. "I think we went about this the wrong way. Cheryl and I talked it over, and we were too heavy-handed. We scared you instead of including you. That was wrong." A pause, perfectly timed. "What we want is for you to be happy and safe. That's all we've ever wanted." "I appreciate you saying that," I said. "We'd like to put a proposal on the table, something that works for everyone." He explained it carefully, in the organized way he explained things when he had rehearsed them. The proposal was this: I would sell the house voluntarily and use the proceeds to fund my own care at a facility of my choosing. Any amount left over, if there was any aftercare costs, which he was careful to note could be substantial, would be preserved in a trust for my benefit. The house would be sold. The money would go into a structure controlled by others. I would live somewhere chosen for me. It was dressed up differently than the original plan, but it was the same plan. "I'll think about it," I said. "Of course. Take all the time you need. There's no rush." There was a rush, and we both knew it, but I let the sentence sit there. After I hung up, I called Robert Castillo and told him about the offer. He was unsurprised. "This is what they do when the legal path looks uncertain," he said. "They try to get you to agree voluntarily to what they couldn't force. Don't sign anything. Don't agree to anything in writing or verbally." "I know," I said. "Do you want me to respond formally on your behalf?" "Not yet," I said. "I want to watch a little longer." What I want to tell you about that period, those quiet weeks in the spring, is that I was not suffering. I know that might be surprising. I was in a legal dispute with my children. I was navigating paperwork and attorney calls and the low hum of anxiety that comes with contested proceedings, and yet I was not, fundamentally, unhappy. The house was still mine. The garden was coming in well. The hummingbirds had found the new feeder I'd put up near the patio. And I was, for the first time in years, not lonely. The case had done something unexpected. It had brought people toward me. Connie had become my daily phone call. And in those conversations, I was reminded of why we had been friends for 25 years. Her frankness, her humor, the way she never softened things that didn't need softening. Ruth had quietly, without being asked, begun keeping notes of our Thursday meetings, recording who was present and what was discussed, because she understood, with the instinct of a former schoolteacher, that documentation of my engagement and lucidity was useful. Beverly had offered her guest room if I ever felt I needed to be somewhere other than the house for a night. I had also, unexpectedly, acquired an ally at the county recorder's office, a clerk named Thomas, who had processed my quiet title paperwork and, recognizing what it was, had mentioned that this type of filing had become more common in recent years, and that there were advocacy resources available. He'd handed me a card for an organization called the Arizona Elder Rights Project, which provided legal and social support for older adults facing exactly this kind of family-based pressure. I called them the following Tuesday. The advocate I spoke with was a woman named Sandra Flores, 40-something, direct, with the cadence of someone who had heard many versions of this story. She listened to mine. She told me I had done nearly everything right, and that the one gap was a formal supportive network on record. Not just an attorney, but documentation of my social engagement, my community, my ongoing activities, that would demonstrate to any judge that I was a participant in the world, not an isolated elder in decline. We built a list together. Book club attendance. Ruth's notes would cover that. Regular attendance at First Lutheran, where I had been a member since 1987. The church secretary confirmed she could provide a letter. My library card history, which showed consistent borrowing. My volunteer work at the literacy program at the branch library, 2 hours every Wednesday, which the program coordinator was glad to document. I was not invisible. I was not diminished. I was not a woman waiting to be managed. I was a woman with a life, and I was going to prove it. They came together on a Saturday in April. I saw Daniel's rental car. He always rented in Tucson, a habit from business travel that he'd never dropped. Pull into the driveway at 11 in the morning. Linda's Subaru was right behind it. They had coordinated, which meant this visit was not spontaneous, which meant it had been planned, which meant it had a purpose that had nothing to do with coffee and conversation. I let them in. I was not going to hide in my own home. Cheryl had not come, which was notable. This was a family conversation, stripped to the principles. Daniel looked tired. The composed efficiency that usually defined him was slightly worn, like a suit that had been slept in. Linda had brought a casserole dish, which she carried with both hands as if the offering of food could soften what was coming. We sat in the living room. I served coffee. We talked about the grandchildren for 12 minutes, which I know because I was watching the clock on the mantel, and which felt like a runway, not a conversation. Daniel asked about the oldest boy's baseball season. Linda mentioned that her middle child had started piano lessons. I answered each question with genuine warmth, because whatever had passed between us legally, those were still my grandchildren, and I still loved them without reservation. But I kept one part of my attention on the room, on the pacing, on the fact that neither of them had driven hours or across town for small talk. Then Daniel set down his cup. "We want to start over," he said. He explained at length what a new beginning might look like. He had a way of describing things that made them sound reasonable and warm, while the structure underneath remained entirely unchanged. The new version of the plan involved me staying in the house temporarily, 6 months, perhaps a year, while we worked together to plan the transition. He would visit more. Linda would help with maintenance. We would tour facilities together as a family so I could feel involved in the decision. "And the legal proceedings?" I asked. "We'd drop them, all of it. A clean slate." He said it easily, as if this were the generous offer, not the removal of a threat he had created. Linda leaned forward. "Mom, think about what you're putting us through. We're your children. We love you. Doesn't that matter?" And there it was, the card that was always going to be played. Love as the argument for surrender. Family as the reason I should let go of the thing that was mine. I looked at my daughter. At the casserole she'd brought. At the careful distress on her face. At the effort she was making to look like a daughter rather than a petitioner. And I thought about all the years I had believed that her sharpness was a shell, and her softness was the truth. I was no longer certain which was which. "It matters very much," I said, "which is why I'm not going to pretend this conversation is about love." Daniel's jaw tightened almost imperceptibly. "You ran a title search on my property," I said. "You hired attorneys before you sat down at that table with a brochure. You questioned my neighbors. You compiled a list of my supposed failures to use as legal evidence." I paused. "That's not what love looks like. That's what a case being built looks like." Linda's eyes filled with tears. Genuine or performed, I couldn't fully say, and I found that I had stopped trying to parse the difference. "We were scared," she said. "We didn't handle it right. We got ahead of ourselves." "Maybe," I said, "but you're still here today, asking me to agree to a timeline for leaving my home. The framing is kinder. The destination is the same. Daniel shifted in his chair. He tried a different approach then, the appeal to practicality, which was always his strongest instrument. He talked about maintenance costs, about the roof that would need replacing in a few years, about the yard and whether I could realistically manage it alone. Every sentence was constructed to sound like concern and land like doubt. He was planting seeds, one by one, into the conversation, hoping something would take root. I listened. I did not interrupt. I let each sentence finish. And then I said, I have a contractor I trust for the roof. I have a yard service I can hire for the heavy work. I have a savings account that can cover both. I folded my hands. I have thought about all of this. I have lived here for 51 years. Did either of you imagine I hadn't thought about it? The room went quiet in a way that answered my question. Daniel stood up. The warmth was gone now. Not replaced by anger, exactly, but by a kind of flat assessment that was, in some ways, worse. He looked at me the way he looked at a deal that had failed to close. You're going to spend everything you have on lawyers, he said, and at the end of it, you'll be alone here, and we'll be estranged, and nothing will have changed, except that we can't be there for you anymore. You are not there for me, I said quietly. You are there for the house. He walked to the door. Linda followed, setting the casserole on the entry table with a small, controlled motion that was somehow more communicative than anything she'd said. At the door, Daniel turned. This isn't over, he said. I know, I said. They left. I closed the door and stood in my hallway for a long moment. The house was quiet around me. The familiar quiet of a place that knows you. The creak of the boards under my feet. The light through the east window making its usual late morning pattern on the floor. I was shaking slightly, I realized. Not with fear, exactly, though fear was part of it. The fear was real. I will not pretend it wasn't. My children had resources I didn't have. Daniel's money, Hartwell and Briggs, the ability to sustain a legal fight for longer than most people could withstand. I thought about what it would mean to lose. Not just the house, though that was enormous, but the right to remain myself. The right to wake up in my own bedroom and make my own coffee and tend my own garden and decide each day how I wanted to spend the hours I had left. That was what was actually at stake. Not square footage, not property values. The right to be a person rather than a problem to be managed. The fear moved through me, and it left something behind. I went to my desk and I opened the notebook. I was ready. The hearing was set for a Thursday in June. The Pima County Superior Court, Probate Division, Courtroom 4C. I drove myself there, which I mention not as a point of pride, but because it was noted in the record, noted by Robert Castillo as part of the day's proceedings, a detail that would matter later. The courtroom was smaller than I expected. I had seen courtrooms in films and on television, those high-ceilinged chambers that make everything feel like history. This was a working room, fluorescent light, institutional carpet, a gallery of plastic chairs. Daniel and Linda sat with their attorney, a man named Warren Blythe from Hartwell and Briggs, compact, silver-haired, with the air of someone who had won enough cases to find them slightly tedious. He glanced at me when I came in and looked back at his papers. I heard, later from Robert, that Blythe had said to Daniel before I arrived, "She has no chance. We have the documentation, we have the pattern, and elderly plaintiffs without family support don't tend to perform well under examination." The phrase that was repeated to me was, "She has no chance." I filed it away with the other things I knew. Judge Margaret Okafor was 60-something, deliberate, with reading glasses on a beaded chain, and the particular patience of someone who has seen many people attempt to use her courtroom as a substitute for conversations they should have had at home. Blythe presented first. He was good. I will give him that. He had assembled the documentation with care. The incidents Linda had recorded, the observations from those early months, statements from two of Daniel's contacts, a geriatric care manager who had evaluated me not at my request or my doctor's referral, but at Daniel's arrangement, through a process I had not been informed of and had not consented to. The care manager's report was 3 months old and described, on the basis of a 40-minute in-home visit in which I had cooperated pleasantly and answered all questions correctly, a person who was showing early indicators of social isolation and executive decline. Robert objected to the admissibility of that report. The judge reserved her ruling. Blythe concluded with something that would have been effective if I were the person he thought I was. A recounting, delivered with practiced sorrow, of 2 devoted children struggling to help a mother who had become, in her grief and her stubbornness, unable to see that she needed help. He described Daniel as a concerned son who had watched his mother grow increasingly isolated since his father's death. He described Linda as a devoted daughter living nearby, doing her best to maintain a connection that her mother seemed determined to sever. It was a portrait of a family at the end of its patience, rendered in sympathetic tones. I noticed that several of the factual details were technically accurate and entirely misleading, which is a specific skill that requires considerable practice. It was a good performance. Robert's presentation was different, methodical. He did not perform. He entered the neuropsychological evaluation from Dr. Reyes. He entered the clearance from Dr. Huang. He entered the letters from First Lutheran, the literacy program, the library. He entered Ruth's meticulous book club records, 14 meetings attended in 18 months, active participation documented in Ruth's schoolteacher handwriting. He entered the deed, the quiet title filing, and the record of the title search run by Hartwell and Briggs 6 weeks before I had been shown any brochure or had any conversation with my children about my future. That last item landed visibly. Judge Okafor looked at it for a longer moment than she looked at most documents. Then it was my turn. I was not required to speak. Robert had told me that, from the beginning, the burden of proof was on Daniel and Linda. I did not have to take the stand. But I had decided, weeks earlier, sitting in my kitchen with the notebook open in front of me, that I wanted to. Not for the judge, for myself. Because I had spent 18 months being discussed, evaluated, documented, and assessed by people who had never once asked me directly what I wanted. I wanted to speak in my own voice, in my own words, on the record. I walked to the stand. I sat. I folded my hands. Blythe approached. He was courteous. The professional courtesy of a man who is certain he is about to win. He asked me about my daily routine. I answered clearly. He asked about my finances. I described my accounts, my investment statements, my system for tracking household expenses, which I had maintained in a paper ledger since 1989. He asked whether I had any difficulty managing complex tasks. I told him I had prepared my own taxes for 42 years. He asked whether I felt capable of making major decisions independently. And here I want to tell you about the 3 words. Because what you might imagine, something dramatic, a revelation, a speech, is not what happened. What happened was this. Blythe asked the question, and I looked at him steadily, and I said, quite quietly, I already have. He paused. I'm sorry? I already have made major decisions independently, I said. I retained an attorney. I commissioned a neuropsychological evaluation. I filed a quiet title action. I gathered documentation of my medical history, my cognitive function, my social engagement, and my financial management, and I presented it to this court. I paused. I did all of that without assistance from my children, without guidance from anyone who stood to benefit from my decisions, and without anyone's permission. Another pause. I believe that answers your question. The gallery was very quiet. Judge Okafor had set down her pen. I saw her look not at Blythe, not at Daniel, but at the folder of documents on her desk, as if she were rechecking something she had already concluded. Her papers shifted in her hands, and one slipped to the desk with a soft sound that, in that silence, carried across the whole room. I saw Daniel at the table to my left, and for the first time in this entire proceeding, he looked like what he was, a man who had not prepared for the possibility of losing. Blythe attempted to continue. He asked about the burned burner, the missed birthday. I addressed both, calmly, with the dates and context I had recorded. He asked about my son's concern for my well-being. I said I had no doubt my son had concerns, and that I hoped he would have the opportunity to express them in a setting that didn't involve attempting to remove my legal autonomy. Blythe glanced back at Daniel once, a brief, involuntary look, and in that glance I saw the first crack in his composure. He had been told this would be straightforward. He was recalculating. Judge Okafor removed her glasses. Judge Okafor spoke for 11 minutes. I know the exact duration because Robert timed it. He told me afterward, the way you note a detail that feels important even before you know why. 11 minutes without interruption, in a voice that was even and cool and left no ambiguity about what she had found or what she intended to do about it. She began with the petition itself. She found it insufficient. The medical evidence presented by the petitioners, Daniel and Linda, relied primarily on a single evaluation conducted without my consent or prior notice by a care manager retained and paid for by the petitioner based on a single brief home visit. She contrasted this with the evidence I had presented. A comprehensive neuropsychological evaluation by a licensed clinical psychologist at an accredited institution, a physician's statement from my primary care doctor of 9 years, and a substantial record of community engagement, social activity, and independent financial management. The standard for guardianship in the state of Arizona, she said, is not inconvenience. It is not the existence of a more efficient arrangement. It is not the preference of family members for outcomes that benefit them financially. She paused, looking briefly toward the petitioner's table. This court must find that the respondent is incapacitated. I do not find that. She turned to the title search. Here her voice did not change in volume, but something in its quality shifted. A slight hardening, the tone of a person who is about to say something that needs to be said, without softening. The record shows that a title search was conducted on the respondent's property by counsel for the petitioners approximately 6 weeks before any conversation was had with the respondent about her living situation or care needs. This court finds that timeline significant. It suggests that the petitioner's concern was not primarily with the respondent's welfare, but with the disposition of her assets. I heard Blythe murmur something to Daniel. Daniel said nothing. Linda, beside him, had her hands folded tightly in her lap and was looking at the table. I watched her absorb each sentence the way you watch someone absorb rain. She could not stop it, and she had stopped trying. The petition for guardianship is denied, Judge Okafor said. The petition for conservatorship is denied. The respondent retains full legal authority over her person and her property. She looked down at a document in front of her. Furthermore, this court is referring the matter of the care manager's report to the state licensing board, given concerns about the circumstances of its preparation. Counsel for the petitioners is advised to review the ethical guidelines governing communications with unrepresented parties. That last sentence was directed at Blythe. He kept his expression neutral, but the hand resting on the table in front of him pressed slightly flatter against the surface. An involuntary stillness, the physical equivalent of catching yourself. I had watched enough people absorb bad news to recognize the reflex. He had not expected the referral. That was not a consequence he had priced into his calculation when he took this case. I looked at Daniel. He was sitting very straight. The composure was intact, the way a wall is intact after the mortar has already started to fail. Holding the shape, but changed underneath. He was a man who had been certain, completely and professionally certain, and who was now sitting in a courtroom that had just declared him wrong in writing, on the record, in language that would be available to any attorney who searched his name in connection with elder law proceedings. I do not know what he was thinking, but I know what certainty looks like when it breaks quietly, and I was watching it. Then she looked at me directly, which judges do not always do. "Miss Calloway," she said. Calloway was Harold's name, and mine, and the name on the deed. This court finds no basis to disturb your independence. Your home is your home. I had promised myself I would not cry in that courtroom. I didn't, but it was close. Outside, in the corridor, Robert shook my hand with the quiet satisfaction of a man who had done his job precisely as it needed to be done. I thanked him, not effusively, because he would not have wanted that, but genuinely. He had been worth every dollar of the retainer. Daniel and Linda came out of the courtroom behind us. Daniel looked as he always looked after a failed negotiation, composed, contained, already calculating the next move. But there was something different underneath it, something that didn't quite have a name, but that I recognized as the specific look of a person who had been certain of something and had been wrong. Not just legally wrong. Wrong about me. Wrong about who I was and what I was capable of and what I would do when it mattered. He had looked at me for 51 years and seen a mother, which is to say, someone whose existence was organized around his. He had not seen a person who had been quietly keeping records for 18 months and building a case with the thoroughness of a woman who had nothing to lose by being precise. Linda looked like she had been crying. Her sunglasses were already on, though we were still inside, which told me she had put them on before we reached the corridor. I stood in the courthouse hallway, and I waited to see if either of them would speak to me. Daniel walked past without making eye contact. Linda stopped. For a long moment, she stood there, and I thought she might say something. Apologize, perhaps, or explain, or simply acknowledge that something significant had passed between us that could not be undone by a casserole or a carefully rehearsed appeal to family. She didn't. She put on her sunglasses and walked toward the elevator. I watched them go. I felt no triumph. I want to be clear about that. What I felt was something quieter. A settledness, like a door that has been left ajar for a long time, finally closing properly in its frame. Then I walked out of the Pima County Courthouse and into the June morning, which was bright and already hot in the way of Tucson summers, with the smell of creosote in the dry air and the sky a hard, cloudless blue overhead. I sat in my car for a few minutes, not from distress, from stillness, the particular stillness of a thing that is over. Then I drove home, to my house, on Elm Creek Road. With the oak tree Harold and I planted the year Daniel was born, and the yellow kitchen, and the pencil marks on the doorframe, and the third stair that creaks, mine. The summer after the hearing was the best summer I had had in years. The garden came in better than it had since before Harold got sick. I planted tomatoes along the south fence and put in a new bed of salvia near the patio. I had coffee on the back steps in the morning and watched the hummingbirds with a quietness I hadn't been able to find in a long time. The book club continued. We had added a fifth member, a woman named Diane, who had recently retired from teaching high school English and had opinions about everything, which suited us perfectly. We laughed more that summer than I remembered laughing in years. I continued my Wednesday volunteer work at the literacy program. One of my students, a man named Hector, 53 years old, learning to read for the first time, passed his first evaluation in September and shook my hand with a formality that undid me completely. I made a change to my will. Robert helped me draft it. The house, upon my death, would go to the Southern Arizona Land Trust, which preserves open desert and working agricultural land. Daniel and Linda were not excluded entirely. I am not a cruel woman, but they were no longer the primary beneficiaries of the property. I sent them each a letter informing them of this, not to cause pain, because they deserved to know. Neither of them responded. I heard, through the ordinary channels of a life lived in a community, how things went for them afterward. Daniel's business had a difficult year. He and Cheryl listed their Phoenix house for sale in October and moved to a smaller place in Scottsdale. Linda's situation was harder to hear about because it was sadder. Greg had still not found consistent work. The children were struggling. I thought about my grandchildren more than I thought about Linda and Greg. Children absorb what surrounds them. Linda called me once in November. She asked if I was well. I said I was. She asked about the garden. I told her about the salvia and the tomatoes. There was a pause. "I'm sorry," she said. Just that. No elaboration, no defense. "I know," I said, and I meant it. I am not a person who requires groveling. What I required, and what I had obtained, was my autonomy. My right to be the author of my own life, in my own home, for whatever time I have remaining. In December, I had the oak tree properly trimmed for the first time since Harold died. The arborist told me it was in excellent health and would outlast both of us by a century. I made my coffee. I sat in the garden in the winter light. I thought, I'm still here, and I was glad. So that is my story. A house, 2 children, and 1 woman who refused to be erased quietly. What I learned is this: preparation is not stubbornness, it is dignity. Document everything. Know your rights. Find the people who will stand beside you. And when someone tells you that you have no chance, that is precisely the moment to prove them wrong. What would you have done in my place? Would you have signed those papers and walked away? Tell me in the comments. I read everyone. And if this story meant something to you, share it. Someone out there needs to hear it. Thank you for staying until the end.